All right, let's go ahead and call the Senate to order. Sergeant at Arms will please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President?
All right, Senators, this evening, we are very pleased to have Pastor Sean Brandon of the Gloria Dei Lutheran Church in Arnold, Maryland, guest of the distinguished senator from the 33rd District. Please rise for the invocation.
Let us pray. Holy and gracious God, you have given us this good land as our heritage, and we thank you for the mountains, the bay, the forests, the farmlands, and the urban centers, and all that comprise this Maryland. Grant that your holy and life-giving Spirit would move every heart in this chamber and throughout this state, that we might indeed rejoice in the diversity of peoples, cultures, languages, genders, and expressions of self found in our Maryland siblings, so that the barriers dividing us may crumble, suspicions disappear, and hatred cease, so that with our divisions healed we might live in justice and peace. Make us a united people that delights in our many gifts, defend our liberties, and give those whom we have entrusted with authority, especially in this chamber on this night, the spirit of wisdom, that there might be justice and peace, and that the most vulnerable among us might thrive. All these things we lift up to you, gracious and loving God, from whom all blessings flow, and to whom all your children might acclaim, Amen, Amen.
Chair recognizes the senator from the 33rd District.
Thank you, Mr. President. I am delighted to welcome Pastor Brandon of Gloria Dei Church in Arnold with us this evening. What I just love about Gloria Dei is how welcoming and inclusive the church is. In fact, its mission is we will welcome all, love and support one another, serve those in need, and grow in spirit. Gloria Dei welcomes everyone, regardless of where they may be in their spiritual journey or what their family looks like. In fact, Gloria Dei has been an active partner with the Annapolis Pride Parade, and Pastor Brandon and his husband Mo, who is here with us this evening, have been longtime advocates for the LGBT community. I'm grateful to Pastor Brandon for being here with us this evening, and I would ask that the invocation be journalized. Thank you.
Without objection, Senator, most certainly we will journalize the pastor's invocation this evening. Thank him for his presence and his work in the community. Thank you. All right, has everyone recorded their presence? It appears so. The clerk will take the call. With 43 members in the chamber, 44 members in the chamber, a quorum being present, the Senate of Maryland is now in session. We have some guests for a resolution that have to get over to the House. If we could start with the Senator from Anne Arundel, 32nd District.
Thank you, Mr. President. Keeping me busy tonight. I would like to welcome the Maryland Council for Social Studies Teacher of the Year awardees. The Maryland Council for Social Studies is an organization dedicated to the promotion and support of social studies education in Maryland. MDCSS works to recognize excellence in social studies instructions at the elementary, middle, and high school levels. These social studies educators are the winners of the Maryland Council for Social Studies Teacher of the Year Award and are receiving recognition for their outstanding contributions to social studies education in Maryland. We thank you for your dedication to the students. We're congratulating Elementary School Social Studies Teacher of the Year, Dr. Stephanie Chopert, the Maryland Civic Education Coalition Civic Leader of the Year, Aaron Few, Secondary Social Studies Teacher of the Year, Gloria Darlington, Promising New York Social Studies Teacher of the Year, Allison Curtin, Social Studies Instructional Leader of the Year, James Scott McComb, and Outstanding Professional at a Social Studies Related Organization, Alexander Sandy Pope, 4th. May I have just a minute of personal privilege before you read the resolution?
Senator, may proceed.
So these honorees were brought to me tonight by a young teacher named Joey Landgraf, which is here in one of these galleries. I'm not sure. Joey, if you're here, will you stand up? Mm-hmm. Joe is behind me. Joey is a social studies teacher at North County High School. And when I first met him, he was a student at North County High School. So I'm so proud of him and the work that he's done. And Mr. Landgraf, thank you for bringing in these nominees. And can we have the resolution read, please?
The clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the Social Studies and Civics Educator Award recipients. In recognition of your awards for excellence in social studies and civics education, thank you for your dedication to your students. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 13th day of March, 2023.
The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the wonderful, wonderful social studies and civics educators, we thank you so much for your incredible service here in the state of Maryland and congratulate you on your award. It is well deserved. Congratulations. All right, we'll do a little bit of a attendee dance here. I think we're up with the senator from the 20. Are we ready? From the 28th district, we have a team joining us. If we could bring in our football players here. Chair recognizes the senator from the 28th district.
Thank you, Mr. President, colleagues. We're here to help celebrate the North Point High School 4A, 3A state champions in football. And while they come on, I just would love to introduce several elected officials from Charles County. Charles County, may I?
Senator may proceed.
Okay. Yeah, Charles County Commissioner President Reuben Collins, it might be in the balcony. Charles County Commissioner Thomasina Coates, I don't know if she's here. And Charles County Commissioner Vice President Ralph Patterson, who's right here.
Oh, okay. Wonderful. Welcome. Okay. Welcome. Okay. We get the whole team, so we're gonna get the wide lens today.
So while they gather, I just wanted to tell my colleagues about North Point High School. North Point High School receives students from all over the county. For half the students, special engineering, science programs, technology programs, and I just want to say that. They represent District 27 and District 28 at North Point High School. Coach Bill Kondo, Athletic Director Andy Shattuck, and Principal Daniel Capel. They're here. I would want to congratulate you for your leadership, gentlemen, of these young men. I just want to also say that they won the state championship by a score of 31-14. I will not say who they beat. But they played at the Navy Stadium on December, I think, 2nd. Right. And I just want to say a quote from the coach. He said, "Coaching is a lot like life. Sometimes you have to make tough choices and you have to make adjustments." So with that philosophy, we can see why they're champions. Mm-hmm. These gentlemen, more than athletes, they are also scholars. So congratulations so much. I'll also say about North Point High School, they're, over the years, the top feeder schools for the University of Maryland School of Engineering.
Oh, very good. So
these young men, whether they're going to engineering or whatever field they are, choosing to go into, their leaders on the field and off the field. So, Mr. President, I request that the resolution be read.
Clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to North Point High School varsity football team in recognition of your victory in the 2022 Maryland 4A/3A state championship. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 13th day of March, 2023.
The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Appears so. The clerk will take the call. Gentlemen from North Point High School varsity football team, congratulations on your fantastic win in the 2022 4-3A state championship. Well done. Great work. Congratulations. Keep up that great work. Senator from the capital city wasn't too thrilled about that one, huh? Yeah. Next year. There's always next year. Good job, fellas. Good job. Arundel. Chair recognizes the senator from District 1.
Thank you, Mr. President. Point of privilege. I'm here now.
Excellent. We will make sure that you are marked. We will unlock your button.
Thank you very much, sir. Appreciate
Excellent.
that.
It's open. It's officially open. All right. Other introductions today. Chair recognizes the senator from Baltimore County.
Thank you very much, Mr. President. Colleagues, please welcome Towson University Outstanding Student Leadership Program. They are here today with students from Towson University and Baltimore County Public School High School Student Leadership. Not only does Towson University have the Dr. Nancy Grasmick Leadership Institute for aspiring leaders in the private sector, government, and nonprofit professional world, but we also have 2 student leadership groups. A couple of us here got to speak with them earlier. One group of student leaders from Towson University and 1 young female student leaders from each high school in Baltimore County. They have joined together for a trip to Annapolis. This is our 4th year for hosting student leaders, and the past 2 years have been virtual. We're so happy that they are joining our state's top leaders in Annapolis this evening. Please welcome them. Thank you.
Welcome, Grasmick Stars. We also are joined by Dr. Nancy Grasmick, who's in the balcony above. So welcome back. Welcome back. Great to see you all. Thanks for visiting. All right. Other introductions? Chair recognizes Senator from 36th District.
Thank you very much, Mr. President. Yes, we had District 36 night tonight down at the Market House. We had a great turnout. I know some of the people might have come up and are either watching in the gallery tonight or they are also over at the house. But I want to thank them all for coming.
Wonderful. Welcome to District 36 residents for making the hike down to Annapolis today. All right. All right. Any further introductions? This chair recognizes the co-chair of the Protocol Committee.
Yes, thank you, Mr. President. Colleagues, I'd like to, we have a group of pages that are back for their second and final session with us this week, so I just wanted to re-welcome them to the Senate. So first we have Benjamin Darasavi from St. Mary's County, District 29, a student at St. Mary's County Public Schools.
Welcome back.
Next we have Catherine Harris from Howard County, District 12, a student at Long Reach High School.
Welcome back.
Kendall Ickner Duncan from Prince George's County, District 26, a student at Friendly High School.
Welcome back again.
Next we have Gavin McIntyre from Somerset County, District 38, a student at Washington Academy High School.
Welcome.
And last we have Marcus Schmidt from Garrett County, District 1, student at Northern Garrett High School.
Excellent. Welcome.
Thank you, Mr. President.
We got the District 38 and 1 on the Democratic side here, the furthest away coming. That's excellent. All right, welcome back. You all are going to have a fun week this week. It's going to be a fun week. We got a lot of work to do. Other introductions? Additional introductions? Nope. Does that do it? Anything else for the good of the order before we jump in? If not, so be considered the reading of the journal from the prior legislative day. Schedule-wise, we're going to be here a lot. So tomorrow will be probably our only day without a double session, but we'll expect Wednesday, Thursday, Friday double sessions, clear for Saturday, and then who knows how many sessions on Monday. So probably 2 or 3 at least. So keep the calendar clear. We're going to be going all over the place, and we'll make it work. We're getting there. All right. This is calendar number 10. House bills. Clerk will read the bills.
House Bill 37, Delegate Stewart, Commercial Law, Consumer Protection, Telephone Solicitation, Stop the Spam
Majority
Calls
Leader moves
Act.
so be considered the reading of the bills. They will be referred to their appropriate standing committees. We've got a report from the Committee on Judicial Proceedings, report number 12. Clerk, read the first bill.
Senate Bill 29, Senator Carter, Courts Prohibited Liability Agreements, Recreational Facilities, favorable with one amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. This bill establishes that any provision in a contract relating to the use of a recreational facility that purports to release the recreational facility from limit, indemnify, or hold harmless against liability for injury caused by or resulting from the negligence of other wrongful act, the recreational facility or its agents or employees is against public policy and is void and unenforceable. Under the bill, a recreational facility is a commercial recreation facility, a commercial athletic facility, or an amusement attraction. The bill specifically includes gymnasiums and swimming pools as recreational facilities. Their amendment number 1 clarifies that recreational facility does not include a unit of state or local government that leases land or facilities to a recreational facility, that the bill does not affect state or local government's liability under the State or Local Tort Claims Acts. In short, in plain language, the bill protects against these commercial recreational facilities forcing people to sign a waiver before they can partake of the activities there, that would indemnify them from any liability, even for actual negligence. And so I was surprised to find this does happen, and I would just explain that and move the favorable committee report with the one amendment.
All right, floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections to the committee amendment? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 291 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 335, Senator King, Real Property, Unlawfully Restrictive Covenants, Modification by Municipalities, favorable with 2 amendments.
Chair recognizes the senator from Baltimore County as the floor leader.
Thank you, Mr. President. This bill authorizes a municipality to execute and record a restrictive covenant modification to an unlawfully restrictive covenant if the subject property is within the boundaries of that municipality and specified notice requirements are satisfied. A person with an ownership interest in the property may decline to have the modification executed and recorded by the notifying municipality within 30 days after the date of the required notice. There were 2 amendments. The first was technical, and the second allows counties to execute and record restrictive covenant modifications within its boundaries after notice. This bill passed out of the committee unanimously. Mr. President, I move adoption of the amendment as well as the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the 2 amendments, Chair recognizes the senator from Montgomery County.
Thank you, Mr. President. Will the floor leader yield?
Yes, ma'am.
Senator may proceed.
Thank you. Could you just give examples, a couple of examples of what the restricted covenant might mean? Is that race and religion? Is it home-based
Correct.
businesses?
It's those types of restrictive covenants. So what this allows the municipality to do is to kind of go in and by bulk just take these things off the record.
Great. Overdue. Thank you very much.
Thank you.
Thank you, Mr. President.
All right, on the amendments, any further discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Chair recognizes the senator from District 1. Oh, nope. On the next bill. Any further amendments? If not, the Senate Bill 335 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 336, Senator Bailey, Waterway Incident Notification System, WINS Work Group, favorable, 1 amendment.
Chair recognizes the senator from District 1 as the floor leader.
Thank you, Mr. President. Now, colleagues, Senate Bill 336 establishes a waterway incident notification system work group. This is going to be similar to 911. There is one amendment. It alters the work group membership and extends a sunset date of the work groups and requires an interim report. This bill did pass unanimously, so therefore, Mr. President, I urge with a favorable, with amendments, move this bill. Thank you.
All right, floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections to the committee amendment? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 336 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 545, Senator Muse, towing or removal of vehicles, reclamation hours, favorable.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President, and ladies and gentlemen of the Senate. This bill limits the generally applicable hours during which a person in possession of a vehicle that has been towed or removed from a parking lot is required to provide an opportunity for the vehicle owner to retake possession of their vehicle. Under this bill, the vehicle must be available to be reclaimed at a minimum, and this is enabling legislation, a minimum 6 a.m. to midnight rather than 24 hours a day. So as it stands now, with those who are contracted by the state police to tow, they are not required to do it 24 hours a day. They are required to do it, let's see, from maybe 8 a.m. to 12. What the private tow truck companies are saying is that they want it to at least be able, should a county adopt this, because again, it's enabling. If a county says, we want to give the opportunity for the private tow truck companies to be able to tow, but not mandate them by law to tow 24 hours a day. And here's the problem. The problem is, in our society today, as it has been tracked by our police officers, 12 to 6 is the most dangerous time for a tow truck company, an operator, to be there for someone to come and reclaim their car. Because most of the time, that time of night, there are people that are irate. They could be, unfortunately, drug dealers, people who are out for reasons that aren't good at all. We had testimony from one of our tow truck drivers that had been shot 4 times because people are irate. And the police have said it's from 12 to 6. All they want is the opportunity to determine for themselves, do they want to work 24 hours a day or just from 12 to 6 to not have to tow cars that day. And in our county, and I'll stop with this, in our county, if that happens, then we have private contractors that are on duty so that a private company would not have to tow. I move for a favorable report, and thank you.
All right, floor leader moves to the adoption of the favorable committee report. Chair recognizes the senator from Frederick County on the
If the floor leader might yield, Mr. President.
Floor leader yield.
Thank you, my friend. Yes.
Senator may proceed.
How are you, my friend? Good to see you.
Good. It's good to see you.
So I'm going to express this again because you kind of made my point again in my reservations in committee, which was, you know, you're right. It's a very dangerous time between midnight and 6 a.m. And if my daughter happens to park in an area that her vehicle gets towed, you're telling me that she can't go and make a call to get her vehicle back by this legislation? They'd be able to shut down and then she would be left out in a dangerous area?
Well, it depends. First of all, it's enabling legislation, and as it is put together, most counties do contract with others to fill that gap that the Maryland State Police, they close. They're not open 24 hours a day. In our county, we contract with private persons to be available for that. And so from 12 midnight, and this is not saying that everybody will do it. This is not by law. This says that most companies are small. They want the work. They're going to work as much as they can. But for those who say, you know what, this is dangerous, and here's what I had to weigh, because I did hear your testimony, and I did hear what you and other senators were saying. When somebody pulls up and it says no parking, and I've been told, I was really ticked off. I've had that happen to me. But when you pull up and it says no parking or you will be towed, I have to weigh that with someone who says my life is in jeopardy in my neighborhood and I want the right to not be open these hours because this is the element of persons who tend to come from 12 to 6 as outlined by state police.
Yeah, and we heard testimony from young women someone who was young and had her vehicle towed. She didn't notice the sign there, and now we're going to take their vehicle and not make it available for them. So now they're in an area that might not be the best part of the neighborhood. Hopefully they got a good battery on their cell phone. But I just find this concerning when I would think that there would be a better way. I mean, it doesn't stop them from being out still towing at that time, because they still go around all these parking lots because they're obviously out towing at that time. So I don't understand what the problem should be that they would be able to pick their vehicle up from the property that they've taken from them.
Nothing in this legislation says that what you said must be the case. Every county that chooses to implement this will implement it in a way that is good for the people that they're serving. I wish I could answer all persons' interest in this, but what I had to weigh was the life of a person who is legally operating a business to say, this will prevent me from being shot maybe for a fifth time from someone who, hopefully, in my day when I was told we didn't have, I'll give my age, when I was told we didn't have cell phones and we didn't have Uber, you're just stuck. But today everybody's got a cell phone, they got Uber, there are many different ways that are different than it was in my day, and I think that this is a time to do.
Well,
and in your county, you can, if you decide to implement that, I think it's a great thing to raise and to come up with some answers that will answer everybody. But no legislation that we pass down here is going to be without some consequences for somebody.
No, I agree, and I appreciate that, Senator. I just think that there would be a better way. These tow companies, like you said, are a business. They want to make money, have a special fee that they charge to go open up. But to be able to close their gates, I find that problematic for a father of two young girls and thinking about that they might not be able to get to their property. All right, thank you.
Thank you so much for sharing that.
All right, on the report, Chair recognizes the Minority Whip on the report.
Mr. President, if I might ask just a clarifying question of the floor leader.
Senator may proceed.
So just to be sure I understand, and I understand the intention behind the bill, I think both of you pointed out the pros and cons pretty well. So this is, this would say that if I happen to be towed, or my daughter or whoever happens to be towed by a company that's elected to not be open from 12 to 6 a.m. because of this legislation, that I can't get my property back before 6:01 a.m.
No, if it's told, if I'm told I got a place I'm taking it to, you can go to that place that opted not to do it. Remember, it's enabling. So your tow truck company may say, you know what, it's advantageous for me to work 24 hours a day. Another one will say, no, I don't want to do that. Somebody is available at some point. And the worst is, yes, you're right, from 12 to 6, for many persons, from 12 midnight to 6 a.m., depending on who towed their car and where they towed it to. I'm assuming if somebody towed it, they had somewhere to take it, and they must be working from 12 to 6. But if that should happen between those hours, you would not be able to redeem your car.
I think I'm a little more, Mr. President, I think if I could respond, I think I'm a little more concerned that I discovered my car was towed at 10 o'clock when I got back to my parking spot at 11:15, and now I've got to figure out how to get it, and I think there's a concern there. Mr. President, I would offer to lay the bill over, but there's not an amendment. I wonder if I could just special order it for a day. I think a couple of members have mentioned some concerns to me. Could we special order this just for a day for tomorrow?
Any objections to the special order?
No objections to that. Thank you. And any concerns, let's get together and work it out.
Thank you, Mr.
Thank
President.
you. Thank you.
All right. On the special order, no objections. Without objection, the bill is special order to the appropriate time tomorrow. Clerk, read the next bill.
Senate Bill 686, Senator Smith, Civil Actions, Child Sexual Abuse Definitions, Damages, Statute of Limitations, the Child Victims Act of 2023, favorable with 8 amendments.
Chair recognizes the chair of the committee as the floor leader.
Thank you, Mr. President. This bill establishes that an action for damages arising out of an alleged incident or incidents of sexual abuse, as defined under the bill, that occurred while the victim was a minor, may be filed at any time. The bill must also be construed to apply retroactively to revive any action that was barred by the statutory period of limitations applicable before October 1st, 2023. The bill repeals existing provisions addressing the filing of actions for damages arising out of the incidents of child sex abuse under 5-117 of the Courts and Judicial Proceedings article, and also repeals provisions of Chapter 12 and 656 of 2017, establishing that the statute of repose in existing statute must be construed to apply both prospectively and retroactively. to provide defendants regarding actions that were barred by the application of the period of limitations applicable before October 1st, 2017. The bill's provisions are severable, Mr. President. And Mr. President, there are 8 amendments. Amendment number 1 is technical. Amendment number 2 strikes unnatural and perverted sex practices language that was repealed by a bill that we passed earlier this session. Amendment number 3 replaces a single incident or occurrence language and replaces it with an incident or occurrence. Amendment number 4 adds requirement that the alleged victim of abuse be alive at the time of filing the suit if the claim would have been barred by the time limitation prior to that October 1st, 2023 effective date. Amendment number 5 removes the cap on economic damages for claims brought against the private individuals or entities. Amendment number 6 changes the damage cap against public entities from $850,000 to $890,000. Amendment number 7 clarifies that school boards need to carry a minimum liability coverage of $890,000 for sex abuse claims and $400,000 for all other claims. Amendment number 8 allows a defendant in a claim brought pursuant to the provisions of the bill to appeal an order denying a motion to dismiss if the motion is based on the defense that the claim is barred and legislative action reviving the claim is unconstitutional. Mr. President, I move for the adoption of the committee report and the 8 amendments.
All right, the floor leader moves for the adoption of the 8 committee amendments and the favorable committee report. On the amendments, any discussion? Chair recognizes the minority leader on the amendments.
I'm going to defer if I could.
Chair recognizes the senator from the 42nd district on the amendments.
Thank you, Mr. President. I wondered if the floor leader would rise to respond to a couple of
Senator
questions.
may proceed.
Thank you. I want to ask a few specific questions about how this bill will work. And I hope in particular the members of the Budget and Tax Committees will pay attention because this bill could have dramatic fiscal effects on our state budget, county budgets, and our municipalities. Let me start with this. Just as a hypothetical, let's say a child in 1950 in Baltimore City 73 years ago was sexually abused by a teacher in the public school system. Under this bill, can that person, now 83 years old, sue Baltimore City for what happened in 1950?
Yes, that's correct. That's the intent of the bill.
And according to the bill, the amount claimed in the lawsuit can be up to $890,000, correct?
That's correct. So right now the current cap for school boards for liability is $400,000. This bill moves that up to $890,000.
And if that person gets a judgment against Baltimore City for $890,000, who's going to pay for that?
Well, that comes from the school board. That comes ultimately from the taxpayers. That's why we. Go ahead.
I was going to say, do we know how many potential claims like this there are against Baltimore City?
I do not know how many there are, and nor do I know how many there will be.
Let's have another hypothetical. Let's say a child in 1950 participated in activities sponsored by the Gaithersburg Recreational Council and was subjected to inappropriate juvenile athlete-coach relationship. Under this bill, can that former child, now 83 years old, sue the city of Gaithersburg for what happened in 1950?
Assuming that the person's alive, yes.
And do we know how many potential claims like this there are against Gaithersburg?
No. The only measure that I could tell you about how many potential claims there are is by looking at the 22 other states that have implemented similar measures. But it's impossible for me to tell you with precision how many cases there there would be.
And in each of the cases of the claims against Gaithersburg, again, the plaintiff could claim up to $890,000 in damages, correct?
That's correct. Now, the transaction and occurrence language is, we plugged that from our Tort Claims Act, and we changed that one A to N to provide more clarity. That's a fact-intensive inquiry, and that's something that a court would have to figure out and suss out. So I couldn't tell you how many claims an individual. You could pose a multitude of hypotheticals. I couldn't give you an answer with any specificity without the court looking at the facts that underlie the case.
So we did not write the language clearly. It's going to be up to the courts to make a decision on a case-by-case basis, correct?
As it is today with the Tort Claims Act, with the Local Tort Claims Act, the State Tort Claims Act, and with the school boards today for any claims that arise under those acts.
Okay. And so to make sure people understand, these cases can be from the 1940s, 1950s, 1960s, 1970s, 1980s, 1990s, and so on. So there could literally be thousands of claims filed against Baltimore City alleging inappropriate student-teacher relationships, and let's say hundreds of claims against Gaithersburg alleging inappropriate juvenile athlete-coach relationships, correct?
That is certainly a potential, it's a possibility under the bill.
And the
Depending on how-
taxpayers will pay the bill for every one of these that hits, right?
If the school boards or the other entities that you mentioned were seen to have been responsible for abusing children sexually over the course of years, then yes, that's what this bill seeks to do, is provide that access to civil justice for children of sex abuse. And so the answer is yes. But for those older claims, I will make mention that, you know, the older the claims, the more difficult the case, even in the civil context. And so, you know, that's a reality that the courts will have to deal with if the claims are brought.
Well, let's explore that for just a second. Now, if we have a very old claim and the person was a child when he was abused or she was abused, it's likely that the abuser is dead and that anybody who might know anything about the abuse is dead, and that the documents, any documents which might have some relevance, have long since disappeared. So in that situation, isn't it correct that you would only have the abused child, now 83 or 90 years old, testifying in court, and the defendant would have no way of making a defense? Wouldn't that make it easier for the plaintiff to win such a case?
No, I don't think so, because again, all the witnesses, the person that would have witnessed or put the entity on notice that there was abuse going on, they would be dead under your scenario. So I don't cede to that, but I just want to draw back and kind of just humanize this whole thing a little bit. Into your scenario and what we've learned from the testimony over years, I mean, we've been hearing that, you and I have heard this bill several years.
Several times.
Several people have suppressed and or through therapy have understood and fully realized and actualized the abuse and trauma that they've gone through. And so to put this kind of false bookend on their ability to seek access to justice because of this trauma that they've experienced and have now only fully realized, I think is unjust and inhumane. And so I know that we're talking about facts and figures here, but there is an element of humanity that I think that we all need to infuse into this process.
Of course.
And as this has gone on throughout the country, 22 states and several others are entertaining similar legislation, I think that you found that there hasn't been the type of financial catastrophe within the public sphere that we are kind of discussing right now. And I just wanted to make sure that we recenter this, and I will continue to recenter this when we go through these exercises on the survivors, because that's really what this legislation is about.
Of course.
And I know you're sympathetic to that. I know you're sympathetic
colloquy
to
is to try to
Yes.
quantify the damages that the taxpayers will have to pay.
No, I understand that.
So there are studies that say that as high as 5% of students experience some inappropriate behavior by teachers. That's a horrible thing, which is criminal today. But if these numbers are even remotely correct, this bill, because you go all the way back and allow thousands of historical claims, could cost our counties and municipalities in the aggregate considerably over $1 billion. Isn't that right?
I couldn't even attempt to quantify any number, so I can't answer that question for you.
Well, let me ask this. Are you aware whether any insurance company sells insurance policies that would protect governmental entities or others from liability judgments arising out of incidents that occurred 40, 50, 60, or 70 years ago?
It's funny, we had an interesting conversation about insurance archivists that go back and see if there, if there's an insurance policy that goes back. I'm unaware of insurance tails, for instance, that would pass back that far. But that's also why, of all the states in the nation that have entertained this, we're the only one that we put caps on the damages, and we're trying to balance equities here. And understanding the difficulties posed, we put caps on damages for private entities at $1.5 million, and then for the state at $890,000. So we think that strikes the right balance, understanding the scenario that you're posing, and that's why we put the caps in.
To come back to the insurance question, the one expert we had testify before our committee stated that he was not aware of any insurance company that sold such insurance, correct?
I believe that was the testimony, and I would believe that. I mean, again, that's why we put the caps in, and I can't quantify that for you. I couldn't tell you that.
Let me give you another hypothetical. Back in the 50s and 60s and 70s, the state and local prosecutors put a lot of juveniles in local jails and state prisons, even many for nonviolent offenses. And we've worked to correct that in recent years, but unfortunately we all know about the horrifying epidemic of prison rapes that occurred back in those times. Would this bill allow all of those former inmates to now sue the counties and state for things that allegedly happened to them 50, 60, and 70 years ago?
Of course, they'd have to prove their case. It's a civil case, but allegedly, yes. Yes, they would all be eligible for this. Again, to recenter and rehumanize, if you're talking about children that were raped because of the state's negligence, children that were abused because of the state's negligence, this bill offers them an opportunity to seek that justice.
Thanks. Let's go to another hypothetical, and this one is a serious one. If a young person in 1970 had a year-long inappropriate relationship with a Baltimore City school teacher and had relations with that school teacher every Monday, Wednesday, and Friday afternoons during the course of that year, isn't it a fact that a single plaintiff under this bill could file a lawsuit containing 156 claims, that's 3 per week times 52 weeks, against Baltimore City? And at $890,000 per claim times 156 claims, the total damages award in that single lawsuit could total $139 million.
So first, under your scenario, let's call it what it is. That's rape, not an inappropriate relationship. That's rape. Second, again, that language is plugged directly out of the State Tort Claims Act. And again, that is a fact-intensive inquiry that a court would have to decide. That's nothing that we could prescribe in legislation. We tried. It's just nothing you could be so prescriptive to say, this is, I'm not going to go over your scenario again, but you couldn't be prescriptive in that sense. So that's something, again, and that's exactly how it works now with the State and Local Tort Claims Act and with the school boards. It's exactly how it works now. And again, you're not seeing the type of financial ruin that you're kind of conjuring up here at the moment, Senator.
Okay. But my math is correct. If you had 156 incidents scattered over the course of a year, the plaintiff could file a lawsuit claiming $139 million, and we'd have to see how the courts dealt with that, correct?
You'd have to see how the courts dealt with that. That's correct.
Okay.
Just like the courts do now, every day.
So let's move from claims against the state, the counties, and municipalities to claims against private entities. Under this bill, wouldn't people who claim that they were sexually abused as children be able to file claims, this time for $1.5 million each, against hospitals, private schools, and other private institutions in precisely the same way as this bill enables them to sue the state, the counties, and the municipalities?
Again, understanding the realities of sovereign immunity, yes, we've bumped up the caps for the public entities, but yes, under your scenario, we've capped that exposure to $1.5 million for those private entities.
So, someone claiming that the chief of pediatrics at Johns Hopkins Hospital abused him on a weekly basis for 3 years in the 1950s would be able to assert a claim against the hospital for $234 million, $1.5 million times 156, correct?
So again, it's a fact-intensive inquiry that a court would have to make that decision. I couldn't answer that question for you. Again, I couldn't answer that question for you.
Sure.
I'm sure that's a potential.
But this bill does set up the possibility that such a judgment against Johns Hopkins Hospital for $234 million could be entered.
Potentially.
Now, there are lots of private schools in Maryland. Has any assessment been made of how many of Maryland's private schools would have to close their doors if this bill were to be passed?
I don't know if there's been an assessment or a registry of how many independent schools have a long and lengthy record of child sex abuse.
So for private schools without endowments, isn't it fair to say that just 1 or 2 judgments of $1.5 million each could bankrupt the schools?
I'm sure that's possible.
So lastly, let me offer this hypothetical. The owner of all 100 shares of stock in a for-profit child care center founded in 1950 sells his stock in 1970 to a new owner, who in turn sells the stock to a new owner in 1995, and that owner in turn sold the 100 shares of stock 3 years ago to the current owner. Under this bill, would it be possible for someone who allegedly experienced sex abuse at the center when he was 6 years old in 1955 to sue the center for $1.5 million, even though the current owner of the center wasn't even born in 1955 and bought the center 3 years ago with absolutely no knowledge that the plaintiff had been abused back in 1955?
I struggled with this. I kind of dubbed this term the third-party acquisition problem, and I struggled with this. And as you know, and a member of our committee actually practices in this area, so is far more well-versed than I am. But when a Maryland business is sold, the corporate law and the agreement between the seller and the buyer determine whether the new company, has the liabilities and the assets. And there are generally 4 exceptions to that. Those exceptions are there is an express or implied assumption of liability, the transaction is a consolidation or a merger, the buyer is a mere continuation of the seller, or the transaction is entered into fraudulently to escape some sort of liability. Those are the general 4.
Couldn't I suggest a 5th?
Exceptions that are articulated in
suppose the buyer buys the stock and therefore buys the business as a going entity. He takes the business with all of its assets and its liabilities. Yeah. So in that situation, which was covered by my hypothetical, where it's the 100 shares of stock that are being sold again and again and again over the years, isn't it fair to say that the business today as an entity is the same business that existed in the 1950s, and that someone could file suit against that business entity for $1.5 million?
Again, I rely on the fact that that's a fact-intensive inquiry, and the court would have to determine that. But the answer to your question is, I'm sure it's a potential.
Okay. And then lastly, I think we've already answered it, but let me just belabor the obvious. Has anyone attempted to estimate the total amount of damages that will be demanded in all of the lawsuits that will be filed if this bill is passed?
I think it's impossible to tell, and the only thing that's remotely instructive is the numbers that come out of the 22 other states that have entertained it, and it's nowhere near kind of the catastrophe that you're projecting here in this colloquy.
Right. Thank you so much for your answers to my questions.
No, thanks. Mr. President.
On the amendments, Senator may proceed.
Yes, I just as a point, I do thank the senator for the inquiry and for the scrutiny of this bill. I know that the senator is obviously someone who's very concerned and has come to work every single day as a true public servant, working to ensure that we provide access to justice to victims of child sex abuse, and that I wish that the record reflect that this line of inquiry was genuine and in a real attempt to make sure that we pass something that is going to make a meaningful difference and that won't hurt the state. So I just wanted to make sure that was recorded for the record.
Thank you, Senator. Yes, Chair recognizes Senator from Baltimore City and Baltimore County on the amendments.
Thank you, Mr. The floor leader would yield. I wasn't going to say anything, but they asked the question about, has anybody done any analysis? And so, again, to recenter, are you aware that has there been analysis about the actual cost of child abuse? And I think part of it is, too, that somehow taxpayers, if people were brought to justice, that somehow, there would be taxpayer are paying for this.
No, I mean, look, thank you for the question, and I thank you for humanizing the debate, and I appreciate both lines of inquiry, but the answer is that it's an incalculable cost, and as someone who's suffered, and for the survivors, it's immeasurable, the damage that it does to the person and to their family and to our society at large.
Well, actually, Safe and Sound did an analysis of the cost in the Bay Area, and they said, if there was 61,000, they estimate there are 61,000 reports of child sexual assault or something over the course of the year, and about 6,800 of them are substantiated. And they estimated, and again, this was done in the Bay Area, and this report just came out in 2021, that $2.2 billion over the lifetime of the cost of a year of abuse by victims. And so again, Mr. President, to do the sort of numbers, if we talk about hundreds of thousands of potential Marylanders, if you multiply that times 2.2 billion, it certainly way exceeds any amount that would probably happen into a lawsuit. Specifically, the way that these break down is that there are lifetime costs. There's a cost that providing services, so we are paying the taxes to provide the services to the child to help them heal. They are 70% more likely to require special education. They are 59% more likely to be arrested, 28% more likely to have an adult criminal record. They are 200% more likely to be unemployed. They are 21% have higher long-term health consequences. The impacts, and that's just on the child. Then there's impacts on the family. And then 25 to 35% of all individuals abused as children will grow up and abuse their own children. So, Mr. President, while there are costs to these institutions that may or may not be culpable, we are already and have been paying over the course of the lifetime of anyone who's currently, we have already been paying. So thank you very much, and I appreciate the opportunity.
All right, thank you, Senator. Any further discussion on the 8 amendments? On the 8 committee amendments, Chair recognizes the Minority Leader.
Mr. President, I move the amendments and the bill lie over under the rule.
All right, the Senator's motion is in order. The bill and the amendments will lie over under the rule. The clerk will read the next bill.
Senate Bill 693, Senator Waldstreicher, Transportation Assaults on Public Transit Operators, report, favorable, 1 amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. As amended, this bill requires the Maryland Transit Administration to submit an annual report on assaults on public transit operators. There is 1 committee amendment. The amendment alters the reporting requirement. Mr. President, I move the 1 amendment and the favorable committee report.
Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now is on the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments? Chair recognizes the Vice Chair of the committee.
Thank you, Mr. President. There is a floor amendment.
Pages will collect and distribute the Senator's amendment. This is the first one of the week. We're going to be very efficient and speedy with it. If senators are not paying attention, feel free to just drop it on their desks and tell. Senator may explain the amendment.
Thank you, Mr. President. This amendment reverts the reporting date of the report.
All right. Any discussion? Senators move the amendment. Any discussion? Any objections? Without objection, the Senator's amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 693 is hereby ordered printed for 3rd reading. All right, let's do, Madam Clerk, let's double check. Do we have everybody? Let's do a quorum call before 3rd reading calendar.
Mr. President?
Has everyone recorded their presence? It appears so. The clerk will take the call. With 47 members in the chamber and a quorum being present, the Senate of Maryland remains in session. We have 3rd reading calendar number 21. Clerk, read the first bill.
Senate Bill 1, Senator Waldstreicher, Criminal Law, Wearing, Carrying, or Transporting Firearms Restrictions, Gun Safety Act of 2023.
Senate Bill 1 is on 3rd reader for final passage. Chair recognizes the Minority Leader on the bill.
Thank you, Mr. President. Could the floor leader yield for questions, please?
Happy to.
Senator may proceed.
Thank you very much. Another bill that we have that deals with constitutions. This is the U.S. Constitution, but I just want to make sure I understand. The Bruin decision eliminates the need for good and substantial reason to carry a firearm, correct?
It declared New York's version of that law unconstitutional. By analogy, our good and substantial reason is also unconstitutional. This bill strikes the good and substantial reason from our law.
So it does that, but then as the state police mentioned in their testimony, Senate Bill 1 expands the list of restricted areas to almost everywhere but the firearm owner's residence. Is that accurate?
So that was testimony as to the original bill.
Right.
The bill has been substantially amended to specifically list the sensitive places where guns will not be allowed.
Okay, and those sensitive places have been determined how?
Those sensitive places were determined by the committee.
And was there a specific reason? I mean, are these places that incidences have occurred, or these places that are unsafe, that the intention of this bill is to now make those places safer?
The intention was to determine which places are specifically sensitive places that, as a policy matter, should be without firearms, like legislative bodies or courthouses.
Well, without firearms. So when you say that, you mean obviously the general population, because obviously we're all protected by firearms right now, correct?
That's correct.
Okay. I mean, it's very nice, Mr. President, that we're able to be protected in the job that we do, but this bill then takes normal citizens and doesn't allow them to be protected by firearms, right? In sensitive areas.
Well, I would disagree with the statement, but there are certain sensitive places, some of which are otherwise protected, some of which are protected by the general police, that are listed under the legislation.
And I think that's a little bit of a concern for a lot of us. What do you mean when you say that they're protected by the general police?
Well, some sensitive places are protected by specific assigned police officers, as we have here. Some places are protected by police officers generally. For example, you're not allowed to take firearms into schools. Most schools, or elementary schools especially, are not protected by an on-site officer, but they are protected by the local police.
And when you say protected by the local police, you mean that the local police will respond if something happens?
Sure.
Okay. So the question on, again, how those of us in this building are able to be protected, those that are in schools have to wait for protection to show up, right? Is that what you're saying?
They are protected by our local law enforcement agencies, correct?
Right, but you said so in other words, if something were to happen in a school, a call would have to be made, and somebody, local police, would then have to respond in order to resolve that incident that's occurring, right?
That's correct.
All right, so again, there's very much of a difference on being able to be protected immediately as opposed to being able to be protected on some period of time once a call is made. And that goes for a number of other sensitive areas, right? We've determined a restaurant that has a bar is now a sensitive area. Is that right still?
A restaurant that is serving alcohol is a place that is listed as sensitive under the bill, correct?
So it doesn't even have to have a bar as long as it's serving alcohol, which most restaurants do, right? I mean, but as long as it's serving alcohol, doesn't have to have a bar, right?
If it is serving alcohol, it comes under the provisions of the bill, yes.
Okay, so another situation where if a individual that is permitted to carry a firearm cannot be in that restaurant with their firearm and an incident occurs, what protects those people in that restaurant the same way that we're protected here?
Well, under the bill, there are a number of exceptions as to whom can carry under the legislation. So that includes the owner of the restaurant or bar, private security, off-duty law enforcement, on-duty law enforcement, and a number of other folks who are accepted from the provisions of the bill.
Okay, but somebody that has gone through the HQL and has the right to carry a firearm and is not one of those categories could not have their firearm there, correct?
Yeah, so an HQL is different from a wear carry permit. An HQL is what allows you to purchase a handgun. A wear carry permit is what allows you to carry a firearm in public.
Okay.
Yep.
Same, but that individual with a permitted firearm could not be in the restaurant to protect their family with that firearm, correct?
Unless they were one of the specifically accepted folks in the bill, they would not, correct?
They would not be able to be protected. This legislation deals just with permitted firearms. Does it deal with non-permitted firearms?
Like you're talking about, does it include long guns?
No, does it include a firearm that's not registered?
An unregistered firearm?
Correct.
You mean the person is not permitted, or the firearm?
The person is not permitted.
If the person is not permitted, they are not allowed under current law to wear or carry.
And what's the penalties for those? For that?
3 years.
3 years. So a misdemeanor?
That's correct.
A misdemeanor and first conviction is up to 3 years?
That's correct.
As opposed to this one, it's a misdemeanor and it's up to 90 days for
Correct.
first offense. So if you have a permit to carry a firearm and you are found to have that firearm, you could be imprisoned for 90 days. If it's not permitted, if you don't have the permit to carry that, it could be up to 3 years.
So it's up to 3 years for a non-permitted firearm, wherever that person may be.
Right.
And it's 90 days, up to 90 days, for someone who has a wear-carry permit only in the sensitive places where they are not allowed to carry a firearm.
Right. How does this law get implemented? Is there a police officer that responds to a phone call that says, hey, I think person over there sitting at the table has a firearm, and the police would come in and check that situation? Or how is it implemented?
Yeah, so the bill does not specify how the act is to be implemented. This would depend on the facts and circumstances of each and every case.
Does this bill then promote stop and frisk?
No, it does not.
I mean, if the police were out there looking for those that are now carrying permitted firearms in sensitive places, that doesn't promote them to stop and frisk somebody to see if that's being taken, if that's happening?
I don't see how it does, no.
Then again, going back to how is this implemented? How are we then finding out or going through a process to find out if somebody has a firearm, a permitted firearm in the wrong place?
Sure, that would depend completely on the facts and circumstances of each and every case, as it does under current law for people without permits.
So does something, I guess my point, does something have to happen? Does a firearm have to be drawn? Does it have to be used? Does it have to be shown for a violation under this bill to occur?
So the same reasons that someone may get in trouble under current law for not having a wear-carry permit, I imagine, are those same circumstances that permitted folks may get investigated in sensitive places. In other words, if the police officer views the firearm, if someone calls the police related to the firearm. Nothing about current law is changing under this legislation.
Okay. But again, nothing in this bill deals with unregistered illegal firearms, correct? That has its own set of laws that deal with that. Is that right?
That's correct.
So nothing deals with it. Okay. Thank you very much.
Thank you.
All right. On the bill, Chair recognizes the Minority Whip.
Thank you, Mr. President. Just rising to speak on the bill and to express my opposition. You know, time and again, in the period of time since we were last together, citizens of Maryland have really been crying out for help to stem a tide of violent crime, and it's been throughout our communities, a tide of violent crime perpetrated largely by repeat offenders, many times using illegal guns. We know the headlines. We've seen them. You can choose to try to explain it away or ignore it. But we've had murders and shootings. We've had carjackings and other types of really violent offenses, many times involving firearms. But once again, this General Assembly is not rushing to deal with the people causing those problems. Once again, the General Assembly is looking to pass restrictions on somebody else. someone else, anyone else to distract from what's happening. And what we're doing with this bill is we're punishing and trying to restrict people who have basically just exercised their Second Amendment rights as law-abiding citizens. It's not easy to get a permit in this state. It is not easy. You undergo a background check, which I totally support. You have to be trained. It's an expensive process to get an HQL for a handgun permit. It's not even really very accessible to people in this state in certain parts of the state because of the hurdles. And it's sort of this relentless focus on Washington, D.C. progressive political priorities. It's really doing a disservice to our state and to our citizens. And on the one hand, in this body, we're saying, when we've talked about protecting another right, it was called, that doesn't actually appear in the Constitution, it's in the penumbras of the 14th Amendment. This right is an actual spelled out right in the Constitution. But the second a glimmer of freedom for a law-abiding citizen was available, in the face of all the things we have going on in our state, with violent crime being committed by repeat offenders, we'll get this bill on the floor real quick. It's a bill on the floor to crack down, to tighten up. This bill should just be a very simple bill repealing what was found to be an unconstitutional statute, and instead we're engaging in this theater where it's now going to have to be taken to court. And make no mistake, this is going to meet, I believe, a fiery end by the court. They're not going to hold it to be constitutional, in my view. I would just ask you to sit here to vote on this. Find me a notable crime in Maryland committed by someone with a concealed carry permit. You won't find, and I don't mean a speeding ticket. Find me a notable crime. I'd love to see one. You won't find it. But we have a lot of notable crimes that are happening and are not being caused by permit holders. Mr. President, I would say enough is enough. We ought to be encouraging law-abiding citizens to exercise their Second Amendment rights in a safe, responsible way. So I would encourage the body to vote no on this bill. Let's get the focus where it needs to be. Thank you, Mr. President.
Thank you, Senator. Chair recognizes the Senator from the 42nd District on the bill.
Thank you, Mr. President. Let me start by saying that this bill that we have before us today is infinitely better than the bill that was first introduced and that was the subject of our hearing some weeks ago in the Judicial Proceedings Committee. And I want to compliment the sponsor of the bill and other members of the Judicial Proceedings Committee that worked very hard to try to make this bill more constitutional than as originally introduced. That said, the bill is still fatally unconstitutional. For those unfamiliar with the Bruin case, which was decided by the Supreme Court last June, let me read you the one sentence which distills the central holding of the case. It says, when a challenged regulation addresses a general societal problem that has persisted since the 18th century, when the Second Amendment was adopted, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. In other words, in order to justify a restriction on a person's right to carry a gun today, you have to point to an analogous restriction which existed at the time that the Second Amendment was adopted in 1791. That is the central holding of the Bruin case. Now, the Bruin case specifically identified 5 sensitive places where firearms can be banned consistent with the Constitution. And this bill addresses all 5 of them. It bans guns in schools, in governmental buildings, in polling places, in legislative assemblies, like this room here, right here, and in courthouses. So this bill covers all 5 of those sensitive places. And if it had stopped there, I would not be rising now to discuss the bill. There have been allegations that it covers other things. The Bruin case, for example, that the Bruin case would permit legislation dealing with heightened emotions. There's nothing in Bruin that deals with heightened emotions. The Bruin case couldn't be more clear on its face. So where this bill goes astray is in banning the carrying of guns in other locations beyond the ones set forth in the Bruin decision by the Supreme Court. And doing that without pointing to any analogous restrictions that existed in 1791. Let me just illustrate this with several examples. First of all, restaurants serving alcoholic beverages. This bill bans carrying guns, firearms, into a restaurant which serves alcoholic beverages. There was no such restriction in 1791 that anyone has called to our attention. And believe me, the advocates for bills like this have been scrutinizing the situation in 1791 to try to find some restriction on this sort of activity. There was none. Consequently, the provision in this bill banning the carrying of guns into restaurants serving alcohol is flagrantly unconstitutional. Similarly, bars, taverns, if you will. Back in 1791, there were lots of taverns. Those of you who've gone to Williamsburg have undoubtedly gone into the Raleigh Tavern and other taverns up and down Main Street, which have now been turned into nice restaurants. There was no restriction in 1791 to carrying your gun into a bar, and therefore this particular restriction is unconstitutional. Racetracks and fairs. Well, they had racetracks back in 1791. They weren't elaborate like Pimlico and Laurel, but they had wooden grandstands, and people went out to watch the horses run. There were also fairs in 1791. No one has called our attention to any restriction back in that era against carrying guns at racetracks and in fairs. Live theater performances. They had live theater performances back in 1791. The people just didn't live in their houses comatose. They went out occasionally for entertainment. No legislation existed in 1791 banning guns in theaters. And finally, the final one I'd refer to is within 100 yards of public gatherings. There were lots of public gatherings back in those days. People got together and talked just the way we do now. And sometimes there was political agitation. There were no restrictions of carrying firearms within 100 yards of public gatherings, or we would have been told about it. So where does this leave us? I'm strongly of the opinion this bill will be held unconstitutional. The afternoon the governor signs it into law, someone's going to challenge it in federal court, and the court probably will enjoin the enforcement of the bill in the meantime, and ultimately will hold the bills unconstitutional. I took an oath 6 weeks or 8 weeks, maybe 9 weeks ago now, and I held my right hand up and I said, I will support the Constitution of the United States and the Constitution of Maryland. That being the case, I believe it would be a violation of my oath to vote for a bill which I believe is unconstitutional, and therefore I intend to cast a red vote on this bill.
All right, thank you, Senator. Chair recognizes Senator from District 6 on the bill.
Thank you, Mr. President. I just want to make a small statement. There was a question that was asked back in 2008, and the question was, does the Second Amendment allow owning a gun for self-defense? In the case, back in the landmark case of the District of Columbia versus Heller, the United States Supreme Court concluded that the Second Amendment includes the right of an individual to bear arms for self-defense. For self-defense. There's people that are law-abiding citizens today that defend their families. We have law-abiding citizens today that defend their property. We have law-abiding citizens that own businesses that defend their businesses. They have so many people that have the right to bear arms and to carry because they're law-abiding citizens. And they're not breaking the law because all they want to do is protect. I believe in this right. I believe in the Constitution, as my fellow senator said. And there isn't any way that I could vote for this bill, Mr. President. That's why I would vote against it. Thank you, Mr. President.
Thank you, Senator. Chair recognizes the Senator from District 4 on the bill.
Thank you, Mr. President. If the floor leader would yield for just a quick question, please.
Sure. Senator may proceed.
Thank you, Mr. President. So I just wanted to be clear because I was listening to the dialogue earlier and we were talking about how this was going to be enforced. And it's where, being that I'm in the profession of law enforcement, I do get concerned about we're putting measures forward and then we're saying that, well, it didn't appear that there was really guidance on how we were going to do this. And there is guidance. And the guidance is that when people call in a concern or they call in a complaint, 1968 decision, Terry v. Ohio, they're allowed. The police will be asked to stop and frisk. So isn't that the case?
So I'm familiar with the case to which you refer. A Terry stop, which is the ability to briefly search a person, is if there is reasonable suspicion that a crime has occurred or if necessary for officer safety. It is a relatively narrow ruling, and but yes, I'm familiar with it.
So it's your belief that if someone sees someone carrying a gun under their shirt or under their jacket and they call the police, that the police would not go up and ask them if they were carrying or if they were permitted, that your belief is that they would just not enforce that, or because there had been no crime?
So I didn't follow who is who in the...
I said if a citizen calls in a concern that they believe someone has a gun on, there's been no crime that they're speaking of, but if someone says, hey, I'm concerned that person has a gun, the direction of police, the guidance is, you're saying, by your estimation, that the police would not stop this person.
If the officer believed there was reasonable suspicion that a crime had occurred, an officer may complete a Terry pat-down. If the officer has no reason to believe that a crime has occurred, then there is no right to a pat-down.
Okay, good. So that takes me to my next concern then, which I appreciate the answer, Senator. You know, friends, I want to be very clear on this. When we're talking about the way this bill is crafted, it is not ready to be voted on today. The way this bill is crafted, it is written that these marginalized communities that we all so vigorously seek to protect, and underserved communities where you have pizza, sub shops, little eateries on every corner. And on every corner of those streets, when you go inside that little eatery, what do they also serve? Beer. If someone walks into that store legally possessing their Second Amendment right to carry for protection in some of these some places I'd say even over-policed communities, and now we're going to have police being summoned to these corners because someone goes into what they believe is a sub shop that sells beer, and by the senator's own statement, subject to a Terry stop. Is that the police state you want here? That's not the police state I want. I want to be able to go in to the sub shop and buy my food and buy my fries, and if need be, take home my beverage. Albeit I don't drink, so I'm not going to drink the beer. But by me being inside the curtilage of that restaurant, I'm in violation of this bill as it's crafted. It is not ready, and I urge you all to give a long, hard thought to this before you vote on this bill. This bill, as crafted, will lead to more arrests, more Terry stops, and an unsafer neighborhoods. Thank you, Mr. President.
Thank you, Senator. All right, any further discussion on the bill? If not, the clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? Chair recognizes the senator from the 37th District has 2 minutes to explain his vote.
Thank you, Mr. President and colleagues. Just a minute to explain my vote. I want to thank everybody for taking the time to listen out the amendment that I offered on second reader. this legislation undermines what we call public safety. I think everybody in the room, everybody in the balcony, we want safe communities. Putting in these restrictions that are contained in the bill, they're going to do more harm than good. The people that want to hurt one another, they want to break laws, they want to steal, they want to rob, they're not going to pay attention to this. This does nothing to improve our public safety. And that's the heart of what we're supposed to be doing. It's a new era. The Bruin decision has changed everything. The HQ law right now is in the Fourth Circuit being reviewed, and it's questionable whether that's going to stand. We can't continue to go down the road of going after gun. The threat to our public safety isn't the gun. The threat to the public safety is the unstable individual, the criminal, the person that wants to do harm. This vote, this bill is going to have an enormous impact on my district. I was nervous to even get up and stand on it. I'm proud of voting no, and I'm disappointed to see it go forward.
Thank you, Senator. Chair recognizes the senator from the 38th District has 2 minutes to explain her vote.
Thank you, Mr. President. To explain my no vote on SB 1, this legislation limits the rights, the constitutional right of law-abiding citizens to wear and carry a firearm. There are law-abiding citizens who have gone through extensive background checks and training that focuses on safety, and they've paid their fees to have that right to carry that gun. No matter how we slice and dice it, this bill limits law-abiding citizens from protecting their own families and the general public. In my district, my constituents understand exactly how SB 1 is limiting their constitutional rights. Just this past Saturday night, about 300 people gathered in Salisbury in support of their constitutional right to carry a firearm. And this is after my constituent, Maryland State Police Sergeant Phillips, was shot by a repeat violent offender out on probation for gun charges and with pending gun charges. Sergeant Phillips told me in my conversation with him, he said, "I'm convinced that if somebody wants to get a gun, they're going to be able to get it. We shouldn't be limiting the rights of our law-abiding citizens." Some of those people, the 300 people, came up here in person. They cared enough to testify at the hearing, at the SB 1 hearing. That's how much they cared. They came up here to exercise their right in person with all of us. So again, when they asked me on Saturday night, when most of us might have been going out celebrating St. Patrick's Day, these people came because they cared enough to protect their own constitutional rights and their families, and they're asking me, they're asking us, when are you going to take action against the repeat violent offenders and not go after the law-abiding citizens? That's why I'm voting no on SB 1.
Thank you, Senator. Any further senators wish to explain their vote? If not, the clerk will take the call. With 31 votes in the affirmative, Senate Bill 1, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 40, Senator Sidnor, Public Information Act, Inspection of Records from Body-worn Digital Recording Devices.
Senate Bill 40 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 40, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 82, Senator Moutz, Correctional Officers Retirement System, Talbot County.
Senate Bill 82 is on third reader for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 47, oh, very good, yes. 47 votes in the affirmative, Senate Bill 82. Constitutional majority is declared passed. Clerk, read the next bill.
Senate Bill 101, Senator Augustine, Maryland Medical Assistance Program, Collaborative Care Model Services, Implementation and Reimbursement Expansion.
Senate Bill 101 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 101, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 104, Senator Augustine, Labor and Employment Apprentice 2030 Commission on Representation on the Apprenticeship and Training Council. This is an emergency bill.
Senate Bill 104 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 104, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 144, Senator Feldman, Public Utilities, Energy Efficiency and Conservation Programs, Energy and Performance Targets, and Low-Income Housing.
Senate Bill 144 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 40 votes in the affirmative, Senate Bill 144, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 156, Prince George's County Senators, Prince George's County Reentry Employment Incentive Program Funding.
Senate Bill 156 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 156, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 184, Senator Vital Health Insurance Diagnostic and Supplemental Examinations for Breast Cancer Cost Sharing.
Senate Bill 184 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 184, having received a constitutional majority, is declared passed. We've got calendar number 22. Clerk will read the first bill.
Senate Bill 185, Senator Vital, Maryland State Police Gun Center firearms surrendered under final protective orders.
Senate Bill 185 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 185, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 215, Senator Ellis, Massage Therapy Discipline.
Senate Bill 215 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 215, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 274, Senator Jackson, State Retirement and Pension System, Earnable Compensation, Non-Vested Former Members, and Immediate Vesting.
Senate Bill 274 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 274, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 322, Senator Vital, Alcoholic Beverages Class 4 Limited Winery License Food Service.
Senate Bill 322 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 322, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 331, Senator Hayes, Baltimore City West North Avenue Development Authority Membership and Procurement. This is the emergency bill.
Senate Bill 331 is on third reading for final passage. Any discussion? Senators, this is an emergency bill. If not, the clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 331, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 334, Senator Hayes, State Procurement Minority Business Enterprise Program, Extension and Reports.
Senate Bill 334 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 334, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 368, Senator Jackson, Law Enforcement Officers Pension System Membership, Emergency Medical Technicians.
Senate Bill 368 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 368, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 369, Senator Jackson, Correctional Officers Retirement System Transfer of Membership Modifications.
Senate Bill 369 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. Chair recognizes. With 47 votes in the affirmative, Senate Bill 369 having received a constitutional majority is declared passed. Chair recognizes the senator from the 37th.
Can I be recorded in the green on SB 185?
From red to green on 185. Any objections? Without objection, so ordered. Chair recognizes the senator from the 32nd.
Mr. President, on Senate Bill 322, may I be recorded in the green?
332 in
322.
322 in the green. Any objections? Without objection, so ordered. We've got calendar number 23. Clerk will read the first bill.
Senate Bill 395, Senator Bailey, State Employees and Retiree Health Benefits, Credible Service.
Senate Bill 395 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 395, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 425, Senator Elfreth, Maryland Historic Trust Historic Preservation Loan Fund Qualified Cooperating Nonprofit Organizations Transfers.
Senate Bill 425 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 425 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 426, Senator King, University Systems of Maryland Board of Regents Quasi-Endowment Funds.
Senate Bill 426 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 426 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 455, Senator Hayes, Real Estate Appraisers Licensing and Certification Qualifications.
Senate Bill 455 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 455 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 466, Senator Jackson, State Retirement and Pension System, Amortization of Unfunded Liabilities and Surpluses.
Senate Bill 466 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 466 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 474, Senator Klossmeyer, Managed Care Organizations Retroactive Denial of Reimbursement Information and Written Statement. This is an emergency bill.
Senate Bill 474 is on third reading for final passage. This is an emergency bill. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 474, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 481, Senator Lewis Young, State Retirement and Pension System, Non-Vested Accounts, Regular Interest.
Senate Bill 481 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 481, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 498, Senator Hershey, Rural Health Collaborative Pilot Repeal and Midshore Health Improvement Coalition Funding.
Senate Bill 498 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 498, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 591, Senator Smith, Labor and Employment, Non-Compete and Conflict of Interest Provisions, Application of Prohibition.
Senate Bill 591 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 591, having received a constitutional majority, is declared passed. Final calendar, number 24. Clerk will read the first bill.
Senate Bill 667, the President. Annual Corrective Bill. This is an emergency bill.
Senate Bill 667 is on third reading for final passage. This is an emergency bill. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. I need this bill for life. It's like my own corrective life. All right, with 47 votes in the affirmative, Senate Bill 667 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 672, Senator Klossmeyer, alcoholic beverages, use of alcoholic beverages for educational purposes.
Senate Bill 672. It's on third reading for final passage. Any discussion? If not, the clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 672 and received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 678, Senator Vital Health Insurance reimbursement for services rendered by a pharmacist.
Senate Bill 678 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 678, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 724, Chair of Finance Committee, Health Insurance Carriers Requirements for Internal Grievance Process Modification.
Senate Bill 724 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 724, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 725, Chair of Finance Committee, Insurance Project and Service Offerings.
Senate Bill 725 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 725, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 827, Senator Hayes, State Commission of Real Estate Appraisals, Appraisal Management Companies, and Home Inspection, Sunset Extension.
Senate Bill 827 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 827 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 833, Prince George's County Senators, Prince George's County Violence Interrupter Support Program Fund.
Senate Bill 833 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 833 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 858, Senator Smith, Firearm Safety Storage Requirements and Youth Suicide Prevention, Jalen's Law.
Senate Bill 858 is on third reader for final passage. Chair recognizes the chair of the committee.
Thank you, Mr. President. I'd like to make a motion to reconsider the vote, which will pass this third reader.
All right, senators move to reconsider the vote by
Purposes of amendment.
For the purposes of amendment, by which the bill passed third reader. Are there passed second reader? Passed second reader. Are there any objections to the senator's motion? Without objection, vote having been reconsidered, the bill is open to amendment. Senator has an amendment. Pages will collect and distribute the senator's amendment. Senator may explain the amendment.
Thank you, Mr. President. A little bit of an oversight here. So we provided for an exception in the reckless endangerment portion of the bill, but we did not provide these exceptions in the safe storage provision. This is the, if you have a natural resources permit or a parent's permission. It was something that was pointed out during committee, and so this just fixes that amendment that we had last session.
All right.
So move for the adoption of the amendment.
Senators move the amendment. Are there any discussion on the amendment? Any objections to the amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 85. Chair recognizes the senator from the 42nd District.
It's not an amendment. Is this an appropriate time to ask the floor leader a question?
Technically not, but
I'll wait. I can wait.
Do we want to wait till third reader?
Sure.
Okay. All right. Without objection, Senate Bill 858 is ordered printed for third reader, and we'll take it up tomorrow or Wednesday. What's tomorrow? Tuesday. Can't do it. Got to be printed. Got to be printed. All right. Let's see. Where are we? Clerk, read the next bill.
Senate Bill 877, the President Annual Curative Bill. This is an emergency bill.
All right, Senate Bill 877 is on third reading for final passage. Any discussion? If not, the clerk will call the roll.
Mr. President?
Has everyone recorded their votes? Anyone wish to change their votes, explain their votes? If not, the clerk will take the call. With 47 votes in the affirmative, Senate Bill 877, having received a constitutional majority, is declared passed. All right, desk is clear. Desk is clear. A long day, long night. No announcements for finance. Nope. B&T, nope. JPR, nope. Yes, Chair recognizes the Vice Senator from Montgomery County.
Thank you, Mr. President. Point of personal privilege.
Senator may proceed.
Thank you, Mr. President. This will be very quick. There was a large bill on third reader this evening, and that bill required a tremendous amount of work from our nonpartisan Department of Legislative Services employees. So if I could just thank them for a moment, Mr. President.
Yes.
First and foremost, Jamie Lancaster, counsel to the Judicial Proceedings Committee, as well as a number of departments that worked hard on this bill, often at difficult hours. The Amendment Office drafters and reviewers, the Bill Drafting Office and their reviewers, editing, as well as fiscal note writers and their reviewers. So, Mr. President, thank you for this point of personal privilege, and thanks to all our professional DLS staff working so hard on our behalf.
Thank you so much, Senator, and absolutely, we are so deeply appreciative. It's a tough time of year for our drafters and the editors and the reviewers, all of them. It's a tough time of year. Yes, Chair recognizes the Majority Leader.
Thank you, Mr. President. Just wanted to, we'll be adjourning tonight in honor of Anita Morris. Anita was the mom of our own Lori Morris that's here on our Senate staff, and she passed away over the weekend, so I'd like to end tonight in memory of Anita Morris.
Absolutely, Senator, we most certainly will, and send our best to Lori and her whole family. Yes, Chair recognizes the Senator from Carroll.
Is it appropriate for announcements, continued announcements? Or,
Senator may proceed.
Thank you. Speaking for the Senate Republican Caucus, we will again be convening at 8:30 tomorrow morning.
Wonderful.
And look forward to seeing our members and anyone else that would like to come.
Thank you, Senator. Yes, Chair recognizes the Chair of the Democratic Caucus.
Thank you very much, Mr. President. The Senate Democratic Caucus will not be meeting at 8:30. We will be meeting at 9 a.m. in the Majority Caucus room.
All right. Any further announcements for the good of the order? For the good of the order. If not, let's do a quorum call before we adjourn.
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 47 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Chair recognizes the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Tuesday, March 14th at 10 a.m. in memory of Anita Morris.
Without objection, so ordered. 10 a.m.